Hi, everyone. My name is Dawn Maselli. I am the co-chair of the Tort Litigation section. I am very excited to introduce our speaker today, Ms. Sheila Tuma. She is the Senior Bar Counsel and Lawyer Regulation of the Florida Bar. She's here today to discuss trust accounts in Chapter 5 of the rules regulating the Florida Bar. She's going to give us some insight into trust accounts and tell us some common errors that she sees attorneys make. We have been approved for CLE credit. So if you did not formally register with the Lee County Bar, please put your name and email into the chat so that Lauren, our wonderful executive director of the Lee County Bar, can email you the CLE for today. Please be aware, I think everybody got the pop-up, but please be aware that we are recording this presentation. So thank you again for being here. And Sheila, I'm going to pass it over to you.
Okay, thank you. Good morning, everyone. Good afternoon. I guess it's already noon. I'm here to talk about trust accounting. The most important thing, I'm going to do a presentation. You'll see a PowerPoint today, but the most important thing to know is that you do really have to understand Chapter 5 of the rules regulating the Florida Bar. It's imperative, even if you hire someone, you'll see as I talk about this, to do your trust accounting for you, you truly have to understand what they're doing and what they're showing you. Because unfortunately, if you read the Florida Bar News, you've seen that there's been embezzlement from lawyers' trust accounts, and they've been from people who work for them for a long time and people they trusted. So it's really important you understand what they're doing and that you also understand what is required for them to do. Sometimes people don't train properly either. So if you don't train the person, they don't know what they're supposed to be doing. If we can share my slideshow now, and I'll start that. Great. If you could just go to the next slide, Dawn, that'd be perfect. Okay, as you can see from the slide, you are responsible. You don't have to hire an accountant. Go back one, please. You don't have to hire an accountant. You can hire anyone you'd like to do it as long as you train them properly and they understand what they're doing. You have to understand, though, the duties are non-transferable. So that don't mean you can come to the bar and say, well, I hired this person. I thought they knew what they're doing, so they're responsible. The court's made it very clear that you're responsible for your trust account. So very important that you provide adequate training and supervision to anyone you allow access to. Next slide, please. There's some requirements that are very specific to Chapter 5 and your trust account. First of all, it has to be clearly labeled trust account. You can't just have your name and say PA. It must be labeled as a trust account. So make sure when you go to the bank that it clearly is labeled that way. Trust funds are really important. You have to promptly provide an accounting when requested to anyone, and you have to disperse them promptly. You must not keep your own money in the trust account. There are lawyers that when we start to audit their trust account, what happens is they leave their fees in there. They're like, well, I wasn't ready to take them out yet. Well, earned fees, you have to take out when they're earned unless they're disputed. So that's really important because that's considered commingling, which is a violation under the rules. The whole idea is your trust account, remember, should only have client monies in there because they're protected. They're protected from your creditors. They're protected from someone seizing the account if there's any issues for you because it is not your money. It belongs to others. Next slide, please. Now, how do you keep track of them? Because they're all in one account. All clients are in that one account. Well, what you have to do is every client is their own client. So they each should have a separate account. We call a client ledger, depending if you do things manually or if you use a computer. Nowadays, hopefully you computerize your trust account and you keep a ledger for each client. Client's name should be on there, whatever other information you think is important on the ledger, such as maybe the type of case it is. But client A's money has nothing to do with client B. That's the first thing. So even though they're kept in the same account, each one of them have to have their own separate ledger card and has to contain the amount of money. You can never use one client's money to pay another. And what's really important about the ledger card, it says, required for each client must start with a positive and be zero or be positive at the end. We get ledger cards from lawyers when they provide us their accounting, and one lawyer, a client will start with negative. We'll ask them, how did that happen? Well, I expected the client's deposit to come in. They needed their money, so I paid them. Their check didn't bounce, Well, of course it didn't bounce because you just used someone else's money. Really, really important. Every ledger card has to start with a positive. You cannot pay a client until their deposit goes through the account and their money's in there. The goal is that every client should zero out. I mean, you shouldn't be holding client money for a long time. The trust account is for short-term nominal funds. So what that means under the rules is you're holding it for a short term for them, whatever that short term may be, personal injury matter, a divorce case where you're holding the money, escrow money for a closing, whatever it might be, it's short term. We've gotten ledgers from attorneys when our auditor is doing an audit. 3 years later, someone still has a positive at the end. So we'll ask, and they'll say, couldn't find the person that check belonged to. Well, you don't want to just keep leaving money in there. So, but a positive you can have at the end, but not a negative. Next one. Timing's everything. You really have to understand your bank. This has been an issue over the years that I've worked on trust accounting cases. Lawyers say, well, I saw it in the account. They put a deposit in there. Right. Well, once you make a deposit, even in your own personal account, you usually can go online and see there's money there. Yes. But did the actual deposit clear the bank? And where we see some of these problems is when a client will give you a cashier's check. I would tell you when I was in banking in the 1980s, a cashier's check was like giving someone cash. Today in 2022, a cashier's check could probably be bogus, fraudulent, very easy with the systems that we have and computers and printers. So you have to be very careful. You have to understand from your bank, how long does it take for a deposit to clear the account, to be available for use? That's really important. Not that it just shows on a ledger, because I've had some attorneys who've made deposits of cashier checks. They paid out on them, and they unfortunately paid out with money very quickly. And it took their bank 7 days to find out that the cashier's check was fraudulent. And then what the bank is going to do, they don't care if you pay that client and the cashier's check related to that client. They look at it as one account. It has money. They'll debit back to your account. And what that's going to cause is a negative for your other clients. The money's gone for the particular client that the cashier's check was bad for. Make sure you know your bank's procedures. Really important that wherever you bank, you should have a banker there that you can talk to. Some of the lawyers will tell me, well, I talk to the teller. The tellers don't always understand all the procedures and when they change. With something as important as your client trust account, you should have someone at your bank you can talk to, one of the bankers, so that you make sure that you understand when these deposits will clear. Next slide, please. Things that can go into your trust account. Well, you can put your own money in there, and you can have a ledger card for your firm, but it shouldn't be more than $100 or $200. That would be sufficient in case there's a charge for, say, printed checks, and you told them, take it out of my operating account, but by mistake, they take it out of your trust account. You'll still have money there and you won't have any problems. Whatever you do, please make sure you keep a ledger card for your firm. Because when you go to monthly reconciliations, comparisons, you're going to be off, because when you total your ledgers, you won't have one for your firm. So you won't know where that difference in the money is. Set up your trust account. Important to say where fees should come from. Whatever you do, make sure that if there's to come from the operating account, that you check they're doing that. If not, it comes from the trust account. Make sure then there's enough money and it gets replenished to pay for whatever's being withdrawn from there. Next slide, please. Non-refundable fees are really important. Lots of lawyers have different types of fee agreements, but they all end up being really non-refundable, but they'll call them non-refundable retainers, flat fees, fee for this case, whatever you call it. If you're telling your client up front that it's going to be non-refundable, it's a flat fee, then it should never go in your trust account. One caveat to that though, say your client gives you a check and you tell them, okay, flat fees, $1,000, but I need $200 for cost. They give you $1,200, then $1,200 that check must go in your trust account. You must remove the $1,000 and leave the $200. Never deposit that check into your operating account and take 1,000 and put in your trust account, because now you've just put client money and commingled it with your own personal funds in your operating account. This is really important. The other thing about a non-refundable flat fee, non-refundable retainer, I know I'm not talking about fees, but I want to give you this information. Under the rules, there's two things. One, must always be in writing. Always. I don't care what area you practice in. If you tell the client it's non-refundable, that must be in writing. Two, don't think just because it's non-refundable, you may not have to return a portion of it. The rules are very clear. Your fee still has to be reasonable. So even though you put it in your operating account, say the client came to you and you put the non-refundable fee in your operating account, then I don't know, 3 hours later, this is a real case, client comes back and decides they no longer want your services. You didn't earn the fee unless you can show you've done something in that 3 hours, gave up a client. There's a number of other things in the rules besides work you've done, but you have to show that you've done something to earn the fee, not just that you have a contract that says non-refundable. So that's really important. Next rule, please. Next slide. Okay, this rule talks about the responsibility of lawyers for the trust accounts. Some years back, the court decided that you need to have a written trust plan for your trust account. Now, you only need this written plan if there's more than you in your law firm. So if you're the only person in the law firm, you wouldn't have anyone to give the trust plan to. But if you have anyone else in the firm, you must include all the names of all the lawyers in the firm that are responsible for the oversight of the trust account. Next slide, please. The trust plan must be disseminated to each lawyer in the firm. And if you make any changes to anything, say you change the bank account, change the, where you're holding the money, then a new plan is required when there's a material change to the plan. Review the rule, because there are really a lot more specifics than I'm going through here in this little thing, but it's really important that you understand if there's two lawyers in the firm, still have to have a plan, a written plan that has to be given to the other lawyer in the firm. Really important that you name who's responsible for the trust account. A lot of times what happens is smaller firms, 2 or 3 lawyers, you know, one person starts to be more responsible for monitoring the individual who's doing your trust accounting, or they're the person doing it. They need to be named in the plan so it's clear who's doing it. Next slide, please. So as I said earlier, your final score is always 0. The goal is always to make sure that every dollar you receive on the client is ultimately paid out. Each client must equal out, no more, no less, as I talked about earlier. What that means is you can't have more sitting there for one client and another client be a negative. One time we had a case in which a lawyer came in and I was taking a sworn statement. He brought his client ledgers, brought all his bank records, and I showed him in his sworn statement that he had clients that were at negatives, he had clients that had balances and had positives. And he said, well, at the end of the month, everything washes out and everybody's okay at the end of the month. Okay, well, that doesn't fly. The court says on a daily basis, you need to have enough money in your trust account every single day for every client you owe money to. So you can't use client A's money on the 15th and say, well, you know, for client B, and client B's deposit came in on the 28th, so I'm okay, because at the end of the month, everyone's back to their normal balances they should have. This is an everyday thing that you're responsible, can never use another client's money. I have people come in and say, well, I was just borrowing the money for the other client. No, you cannot borrow from your trust account. You cannot borrow for another client from your trust account to pay someone else. Next slide, please. Who should sign your trust account checks? I've started doing this work in 1986 in Illinois, and I worked on trust accounts there. I worked on trust accounts here. I would say no one should sign your trust account but you, but the rules do not require that. You can have someone else, you know, sign your trust account checks if you want. But if you do that, I'd be sure to review all your check images front and back. Be sure you have access to print the front and back. You need to keep them and all every month. Check your account balance daily online, and make sure that you get all the bank statements if they come to your office. The thing about allowing someone else, so you know, to be a signatory on your trust account means when you say to the bank, well, they weren't supposed to write that check, the bank's going to say to you, well, you made them a signatory. Bank isn't involved in whether or not you told the employee that you let be a signatory. I only want you to write these checks out to this client, and then they write one to themselves. Bank doesn't care. You made them a signatory. It's not a forgery because they could sign. The other reason you should always look at your check images, if you are the only person who can sign on the account, it's also to make sure someone isn't forging your name. We've had cases where, one case I remember back when I first started for the bar in 1999, where a employee was forging two partners' signatures on trust account checks, and the bank kept calling because they were kind of concerned that the signatures didn't look right. And what did the partners do? They referred them to the employee so she could figure out what was going on. And she would tell them, oh, so sorry, they were in a rush. They signed that way. I'll make sure they sign better next time. So the bank was trying to give them a heads up, but they were giving them to the person who was stealing from them. So again, really important that you do everything you can to make sure that doesn't happen to you. Next slide. Okay, payments you cannot make from your trust account. This is really important because we've seen this happen over time too, where lawyers talk with their client, try to convince their client of something they need to do. And then the client says, no, I don't really want to do that. I'm not giving you authorization to pay that doctor because I wasn't happy with the services he provided. And they'll put that in writing to you. And then, or they'll say, no, I don't want you to disperse that escrow money right now because I think that, we should fight the contract. But they put that in writing, then they change their mind. Make sure that when they change their mind, they put it in writing, not on a telephone call with you or just in person. You want to never disperse anything from your trust account that's not authorized by your client. It has to be authorized. Then you have to make sure if that authorization changes, you get it in writing. If legal fees are disputed by your client, they must stay in there. What's also important, if you do personal injury and you've signed a letter of protection, anyone who does personal injury will know what that is, but you're protecting the doctor or you're protecting a hospital. Whatever it is you sign that letter of protection for, you have duties to that third person. So when it says anything not authorized by your client and your client says, or your client says, yeah, I authorize you to pay me, but not them, you cannot pay the client the money that was due the doctors or the medical providers, or if there's a lien by statute, like Medicare or subrogation lien, you have to make sure that you hold that money. Even if your client's saying, I want you to pay me, you can't. Because at times with your trust account, you may have a duty to a third person. Or if there's an order from the court to do something specifically, then you need to follow the order from the court. If your client disputes it, then make sure that you have something from the court that authorizes you to do what you do. Your trust account is so important. If you read the Florida Bar News, you'll see a number of attorneys who have problems with their trust account. We actually have an educational program that we give to lawyers when they end up with a bar complaint. There's no stealing of any client monies, but they're just not keeping the right records, not keeping track. We will send them to our trust accounting workshop because it's really important that you understand. Chapter 5 is very specific in the state of Florida. So you really have to understand what you can do. Also, personal expenses. We have lawyers that do this sometimes. They leave their fees in there and then they'll pay their mortgage or they'll pay their children's school. Cannot do that. If you have fees in your trust account and now they're due to you, whether you've billed against them or whether they were one of those non-refundable fees that I told you had to go in there and then be dispersed, you have to disperse it payable to your firm, not for personal expenses. You must pay your personal expenses out of your own personal account or your operating account. Next slide, please. Now, chapter 5 has a couple different things besides all these other things I've talked about. They have records you have to keep for your account and then procedures that you must do with your account. I'm going to start first with the records because it's really important that you understand what records you need to keep for your account. Because a lot of times when we issue the subpoena for our auditor to get records from an attorney, they don't have all these records, or if they have them, they're not kept as required by the rules. So that's really important. But you have to keep your bank statements. Now, most people are online, so you don't get bank statements sent to you. However, online, most banks only keep your records online 18 months, 2 years, so you can go back and print them. So what I always suggest to lawyers is you have to keep your records for 6 years from the date you made a disbursement. So what I would suggest is that you have somewhere that, one, you either take the PDFs of those bank statements and then you move them over somewhere. I'm a firm believer in having both electronic and paper because you just never know what can happen with your electronic information you keep. So one of the things that I always suggest is that you print out the bank statement, you keep whatever council checks for that month with it, the deposit slips for that month. I always suggest the item you deposited, you know, the actual check, whether it came from Allstate, whether it came from, you know, somebody providing escrow money, make a copy of the front of that and keep that with your monthly statement. It just helps you better understand whose money you deposited. So you have to keep a bank statement. You have to keep a journal. A journal is really important. Now, a general journal is everything that happens in that account. So what that means is day one, you deposit $1,000 for client A. That will be on there. Day two, you deposit money for client B. Day three, you make a disbursement for client A. Every transaction you do will be on that journal, whether it's a deposit or whether it's a withdrawal. Now, the client ledger cards is where you'll have specifics just related to one client. So that client A, you made the deposit on January 1st, 2022. That will be the first transaction on their client ledger card. If you make a disbursement for them on January 15th, that will be on their ledger card. But you had other transactions in between that time, but they don't relate to client A. So that would not be on their client ledger card. Deposit slips are very important to keep. A deposit slip is not just the slip. Under the rule, look at the rule. There's specific things that must be kept on the deposit slip, such as the client's name, where the money came from. So again, if you kept the front of the item deposited, that could help you fill out your deposit slip way easier. Your canceled checks, as I said, banks don't send them back to you normally. So you need to go online and you need to have the front and back. That's what a canceled check is. The front and back of the check after it's gone through your account. Because the reason for that is so that we can see who signed off on it to make sure that it went to the proper person, it was negotiated properly. So really important that you keep all those records for 6 years. As I said, I think electronically is great. Up in the cloud is nice, but I think keeping yourself paper as another backup would be a good idea. And make sure whatever computer system you're using, again, this isn't a technology seminar, but I would suggest you go to Legal Fuel and take some of their technology seminars. There's really good ones about making sure that you have the right backup, that wherever you're using your information in the cloud, you can get to, that there's no problems with it, because it is important that you can get to this information when you need to. Next slide. So now, as I said, that was a lot of the records you need to keep. There's different things you have to do on a monthly basis just for procedure wise. The first thing you have to do is a monthly bank reconciliation. These are really important. Again, if you have someone else do them for you, you need to understand what they are. We were taking a sworn statement of a young lawyer who had hired someone in town. He was in a small town here in Florida, and she had told him she worked for a number of lawyers. She knew how to do accounting, and he was like, oh, good, because I really don't know anything about accounting. When I was taking his sworn statement, I asked him if he saw monthly bank reconciliations from her. So, you know, she was embezzling from him. And he said, yes, every month she showed it to me. I don't even understand how she could have been stealing money. So I had shown him a monthly bank reconciliation because when she stole the money and when she was getting caught, she disappeared with his records too. So we had to reconstruct his trust account for him. And when our auditor provided me the monthly reconciliations, I showed them to this young lawyer and he said, what is this? And I said, it's a monthly reconciliation. And he said, I've never seen anything that looks like this. So I asked him what she was showing him. And he described it to me as a piece of paper that said bank balance at the top, checks, and listed some checks he believes. And at the bottom, it says balanced. That's not what a monthly reconciliation looks like at all. So he said the numbers at the top and the bottom matched. Whatever it said was in the bank said it was on the monthly statement. So he believed that she was not doing anything wrong. He knew nothing about Chapter 5 and what was required. He relied on her because she had told him that she had worked for a number of law firms. So the next question I had for him is, did she fill out an application with him? And he said, yeah. And I said, did she list the law firm she worked for? And he said, yeah. I said, did you call any of them? He said, not when she started. So you have since, yes. And all three law firms she worked for, she had stole money from their operating accounts, not their trust account. She found him and realized he knew nothing about money that was going in. He didn't know anything about how to do his trust account, so she found it easier. He didn't have much money in his operating account, but he had more money in his trust account. So again, really important that you, if you're going to delegate this to someone, you understand what they're doing. So when they show you something, you truly understand that it is accurate. And I cannot stress enough how important it is you go online and make sure you don't see anything that doesn't look right in your trust account. So after a monthly bank reconciliation, you also have to do a monthly comparison. This will be that reconciled balance that comes from the reconciliation up, and it'll match to your ledger cards. This is why it's so important that you make sure you have a ledger card for the firm, because the ledger card for the firm needs to be added up with the total of all the other ledger cards to make sure you match the reconciled balance. I would tell you probably 5 out of 10 times when we subpoena a lawyer, we will get a call back and say, I gave you my monthly bank reconciliations. Why do you keep asking me for a comparison? What is that? So that tells me already they don't know what needs to be kept for their trust account. So really important, they're two different things, and they're a check and balance against each other to make sure that your trust account is being kept accurate and that you have the client money in there. The last thing you need to keep is not on a monthly basis, but on a yearly basis. At the end of the year, you should have a list of all client balances. The hope is by the end of the year, you don't have many clients left with a balance. Because remember, our goal is what? 0. So if you get to 0, you don't have to list them. Because what does the annual listing say? Only if the client has a balance. So more likely than not, your people on the annual listing should be just a few probably near the end of the year that you still have not been able to disperse, the closing hasn't gone forward, or the personal injury matter, you haven't been able to get them in to sign off so you can disperse the money, or there's some dispute regarding your fee, whatever that may be. Those are the only people that should be left on your annual listing. Next slide, please. So here's a little bit about what a bank reconciliation will do for you. A bank reconciliation is going to be that ending balance on the bank statement. Bank statement is going to have an ending balance there, some balance for that month. If for some reason a deposit that you sent in, maybe you sent it in, through the mail, maybe you made the deposit through the ATM, whatever it is, that deposit may not be there. So you need to add that in. What if there's some checks that haven't cleared? Okay, then you need to deduct those outstanding checks, because to get a reconciled balance that agrees with your journal balance, you have to make sure that you've taken care of any deposit that's not yet reflected and any check that hasn't yet cleared. Because remember what I told you originally when we first started, that journal you're keeping every day of what happens in your trust account, that has to match and reconcile with that bank balance. So if you get to January 31st, and your bank statement says you have $50,000, but there's some outstanding checks that have been taken care of, remember your journal is already going to have a minus for every check you wrote. Because when you write the journal, you write it on a daily balance. You don't write in the check after it clears your account. You write it in your journal as you write the check. So this is really important that you, one, understand what a bank reconciliation should show you, and you should understand how they got to where they got to. Because you should be able to look at your journal, look at that bank reconciliation, and know that the person who's keeping track for you has done it appropriately. If you're doing it yourself, this will help you make sure you haven't made a mistake. It could be a math mistake that you added or subtracted, not appropriately if you don't use a computer. It could be an error where you forgot to write in a check you wrote. In the early 80s, I worked for a law firm right when I started law school in Chicago, and they had a bookkeeper that worked for them for, several years, and she left. And they didn't hire me until like 10 months later after she left. I can only tell you when I started their books, and back then there was no computers or anything to put it in, I had to do this all manually. And when I opened up their books to start putting the information in, I had to go back 10 months. One thing I learned from them was they seemed to write checks and forget to tell you they wrote a check. So I got to the point they didn't get a check until they told me what check number they were taking, and then would have to come back and tell me who they wrote it to and for how much. Because one of the things when you're keeping track for a lawyer is you need to know all the checks they write. You can't wait until the monthly statement comes back, because as I just told you, what if a check didn't clear? Then your journal would be off and you'd never be able to reconcile it. Next slide, please. Okay, so remember that was our reconciliation. This is our comparison. The comparison is very important because this is where every one of those ledgers I told you about, you need to have a balance on them. Remember, balance should be positive. If there's zero, you don't need them for the monthly comparison because there's nothing there. Should be no negatives. So every client ledger, your firm, you should add that all up. That is your trust liabilities. That means that's how much money you owe out of that trust account to your clients. You should be able to compare that to your reconciled bank balance. What should it be? Equal. Okay, as that young lawyer told me when he saw everything, he said top match bottom, right? Because she just wrote things in, and of course they equaled each other. But what he never looked at were ledger cards. What he never really saw was a real reconciliation. Here, that's what you would be doing. Those ledgers would all be added up and they go to your reconciled bank balance. They should match. Don't match, you got to figure out what's going on. If you got an overage, got to figure that out. Why do I have an overage? Did I forget something? Did I not write something in somewhere that I actually paid out? Do I have a shortage? That's a bigger problem. Why do I have a shortage? So you want to figure out what that problem is. And if you do this on a monthly basis, remember, because this is monthly, you're supposed to be doing this, you could catch somebody who embezzles from you. I can only tell you the lawyers who end up, and you can look at Supreme Court cases, lawyers who have been disciplined for embezzlement from their trust account, not them stealing, someone stealing from them, was because it went on for a long period of time. And that means to the court, you weren't monitoring your trust account. You weren't doing what you were supposed to do. It is your obligation, whether you delegate it or not, to ensure that your client's money is safe at all times. And definitely on a monthly basis, if not daily, when you look in your trust account. But if you can catch something monthly and someone forged your name, if you remember when you get your statements from the bank, they'll tell you if something's wrong, tell us, right? So you definitely want to tell them. I had a lawyer who had someone who stole money from him. An employee worked for him, I think, for about 12 years. Very, very long-term employee. He trusted her. She had done his books for a long period of time. And one day he ended up with a non-sufficient fund notice that came to the bar, because your bank has to notify us. And we wrote to him and he said, this is impossible. I'm going to go talk to her. I know she keeps my books up to how she's supposed to. He then called me back and he said to me, I cannot believe this. He said, my employee said that her fiance was ill. She had borrowed some money out of my trust account, and she's going to pay it back. And I asked him how much money she borrowed. And I can't remember if he told me 10 or 15,000. And I told him, you need to hire an accountant, a CPA, to go through your account, find out what was taken. It's probably 3 to 5 times that amount. And the first thing he said to me is, do you know Michelle? I don't know her at all. I said, I can only tell you, my years experience tell me once they admit to stealing from you, it's never the amount they've stolen. Unfortunately for him, his employee had stole $101,000 by the time he learned of it. She had been stealing for over 2.5 years. The sadder part of this was he went home, explained this to his wife. He said to me on the phone, I told him, you need to get the money back in the trust account. He goes, well, Michelle tells me she doesn't have it. Well, let me tell you, people who embezzle from you are not putting it in a savings account to earn money. They're using it to live on, to pay for things, buy things. So I explained to him it was his obligation to put the money back, because it is your obligation as the lawyer. He told me that he had some accounts. One was a school account for his children. They'd been saving for their education. He had a retirement account. He asked me if he could have till the next day to go to the bank and transfer that money over to his trust account. Told him fine. Next morning, I get a call. He's hysterical. I'm like, what happened? He's like, I cannot believe what just happened to me. He goes, I went to the bank and they told me there's no money in those accounts. I go, well, yesterday you told me there was plenty of money in those accounts. He goes, well, when I went home yesterday, I told my wife what happened. And she was very upset with me for not monitoring my trust account. And when I went to the bank at 10 o'clock this morning, his wife, so you know, was on the accounts, the children's account and their retirement account. They told him that all the accounts have been changed into his wife's name because they were joint accounts. So she changed them over and moved the money into an account in her name. He wanted me to call his wife and see if she would agree to give him back the money. I told him no. I really cannot get involved in any marital disputes. Eventually, he was able to borrow money from family and put the money back. But it's a sad story when it gets to the point where you have to put back money, because I promise you, I've never seen one person who embezzled, never. And I've seen a lot of embezzlements since 1986. I started doing this till today. And I've not seen one person who embezzled have the money available to pay. I have had lawyers, when they prosecute them, the states say that the person has to pay back restitution, but you have to put the money back way before then. I've had lawyers have to sell their homes to get money to put back in their trust account. This sounds scary. I hope it is, because it's really important that you understand what goes on with your trust account and that you keep track of things. Next slide, please. As I said earlier, you're required under the rules to keep all your trust account records for 6 years. Remember, when I say trust account records, it's important that you read the rule. Excuse me. It's more than just your monthly statements, more than just your checks, more than your journals. You have to keep all backup to any disbursement you make from that trust account. So really important. If the disbursement was, say, for your fees, then you should keep your fee statement. Say the disbursements to a medical doctor, you need to keep that bill from the medical doctor. So that's your backup. Your backup's really important to keep with those records for your trust account. So as you see, it doesn't say keep your financial records only. You must keep all trust account records that are required under the rules. So again, and they have to be kept for 6 years. One of the things I told you earlier that I would do if I were keeping someone's books for them on a monthly basis is I kept track of that monthly statement, that check I told you to keep, remember, with it, your deposit, a copy of the item deposited, every check that would be with a monthly statement that I would keep whatever the backup was for that. So if it was to Dr. Brown, next to that check, I would attach Dr. Brown's bill. If it was to your PA for fees, I would keep a copy of either the fee statement if you're billing by the hour, or your retainer agreement that said it was non-refundable and that you're moving it back over. Pay costs to the clerk, make a copy of whatever you've done to pay the cost. Again, if you keep that all together by the month, it'll be way easier to find if you get questioned by anyone. And as I talked about earlier, storage of your records. It's real important that you keep them. I can't stress enough, especially in a state like Florida where hurricanes come through here. Don't just keep paper and then your building gets hit and then all your paper is destroyed. Keep electronic backup. Don't keep it in your office in this just one spot, because again, if something happened in your office, now your electronic's gone, your paper's gone. And backup's important, because if you keep the backup, really doesn't matter if that computer that you personally are working on is gone, because the backup is going to be kept somewhere else. Next slide, please. One of the other problems we see with trust accounts that lawyers have issues with is making mistakes, writing a check out of their trust account when it should have come out of their operating account. This happens a lot, mostly to lawyers that are in smaller firms or sole practitioners, because the problem becomes that sole practitioner sometimes is the person who does everything for the firm. That means they write the check. So they keep checks in their drawer, and all of a sudden someone comes in and says, oh, we've got to pay for the water that just came in. Takes out a check, writes it, and don't realize they didn't write out of the operating account, they wrote out of the trust account, because they keep it at the same bank. So one of the things we suggest is you might want to keep different colors for your trust account versus your operating account, so you don't make that mistake. Also, if you don't use your trust account as often, I would suggest that you lock those trust checks somewhere separate from your operating checks, because your operating account you're probably going to use more often, and that could be accessible to you. Your trust account should never have ATM access. There's no overdraft protection you can have, because why? Your trust account should never be overdrawn. And you shouldn't be going to an ATM to get cash. If your client tells you, I don't have a bank account, what am I going to do with a check? That's fine. Write them a check payable to them and tell them they can go to your bank, because as you know, if you take a check to the bank where it's written, that bank will negotiate the check as long as there's money in the account for the person. You will not be writing checks to cash. Do not write checks on your trust account to cash. How are you going to back up cash? Because we have no idea what happened to a check that's payable to cash. And you can't go to an ATM machine and hand the client cash. Next slide, please. This is our auditors. They're really good. They're all CPAs. We have one in every one of our branches, but they always tell us, tell them there's always a danger in one person having control of the entire trust account. That's probably true. Be really nice if you had one person who can make deposits, different person write checks, one person be the person who kept track of your journals and your ledger entries. However, most firms are lucky if they have one person that does everything else in their firm besides doing your trust account. So if you're not the person who does the trust account, the only thing you possibly can do to try to avoid something happening with your trust account is to make sure that you're diligent in looking it over, going online, checking the balances, asking to see things, asking questions, making sure you don't see any checks out of your trust account that don't seem right. That is the only way you're going to be able to make sure nothing happens to your trust account. But with all of that said, you really truly have to understand what records are being kept for your trust account and what those records mean. Next slide, please. Here's some of the things I've learned over the years of people who embezzle from lawyers. Believe it or not, I've had some people come in for a sworn statement who have embezzled from lawyers. They're not even a lawyer and they come in for a sworn statement. But I ask them, they come. And some of the things I've learned is you'll see things like they have a family crisis or their living becomes more extravagant, gambling addiction. We've had some that have drug addictions. But here's the biggest thing that I've seen that lawyers really don't seem to get is overprotective of their work and vacation time limited. Let me give you some examples of overprotective of their work. I called one lawyer one time and I indicated to him my auditor needed some additional records in doing his audit. Asked if he could send them to me. And he said, oh, can you wait 2 weeks? And I said, are you in trial? I was trying to figure out why he needed 2 weeks. We were only asking for a few things. He said, well, no. He said, but the individual who works for me, who does my trust accounting, she's on vacation. I said, okay, well, I'm only asking for some of the journals and some of the client ledgers. And I go, they don't need to be filled out by her, do they? And he goes, well, no. But she takes everything to her house with her when she's on vacation. Is she working for you from her house? No, but she says that that's the best place for the records when she's not in the office. Well, why would that be the best place for the records? Most likely than not, because she doesn't want anybody to look at what she's been keeping or doing. So be very careful. I had another lawyer tell me he couldn't get into the employee's desk because the drawer she keeps his records in, she locks, which is a good thing, to lock your records. But I go, don't you have a key? She said she thought it was best she'd be the only one with a key. Again, be very, very weary of people that work for you and start wanting to have total control of your records to your trust account. I have some lawyers who tell me they don't have the password to get online. I go, what do you mean you don't have the password? Well, my employee told me she would need to change it so often. So I don't really know the password to get in. Well, if you don't know the password to get online, how are you going to review your records? How are you going to see what's going on? I'm not saying everyone that's overprotective of their work or wants to protect you by locking things up is going to steal from you. But it also gives you no opportunity to look at anything if they're keeping the passwords to online banking, if they're locking up things in their drawer. So again, you're not reviewing the records. That could be a possibility of somebody stealing from you. Next slide. Okay, what happens when you discover embezzlement? I talked a little bit about this earlier about some of the examples I gave you. You definitely have to put your own money back into the trust account. The court is adamant, it's your responsibility. If you failed in that responsibility to keep track of client money, you need to put that money back so your clients are protected. I would always recommend you retain somebody, an independent CPA firm, to look at it, notify the bar, notify the state attorney's office, and obviously become involved in your trust account records so you know what's going on. Next slide. This is my last slide. Then I'll take any questions if you have them. But our ethics hotline, I leave you with this, and it's not just for trust accounting. Please avail yourself to them. They are great. They have wonderful information. You can ask them questions. They'll give you an informal advisory opinion about whether or not something should be done. Please know it has to be your own prospective conduct. Don't call them up and say, Joe down the street is advertising this way, or he's done this, can he do that? They're not going to answer that question for you. They're going to answer questions for you to help you understand what you can and can't do. Also, each of our branches have an auditor. So if for any reason, depending where you're located, if you're all in the Lee County area, that would mean the Tampa branch. You can contact them, ask to talk to the auditor if you have a question. And same if you're anywhere else in the state, we have auditors in each of our branches. We're more than happy to try to walk you through something if you're unsure of something. We're here to help you. We want you to understand the rules, and we want you to be able to protect your clients' monies. And that's it for me. Thank you.
Thank you so much. Does anybody have any questions? Okay, no questions. Thank you so much, Sheila, for joining us today.
Thank you.
That was a wonderful presentation. As a reminder, if you did not formally sign up with the Lee County Bar for to register for this presentation, please put your name and email into the chat so that Lauren can send the CLE information to you.
Thank you. Everyone have a nice afternoon.
Thank you, everyone.
Thank you. Take care.
Thank you.